One Supreme Court ruling changed what police can do the moment a gun stop turns into an arrest. And if you still think officers can freely dig through your phone after finding a firearm, you could be dangerously wrong. Quick question before we continue. Are you subscribed? Because what I'm about to break down could help you avoid a life-changing mistake during a traffic stop. Hit that button now. Here's what makes this case so important. A lot of gun owners focus on carry laws, magazine bans, and where they can legally keep a firearm. But this ruling hit a different pressure point. It hit privacy. And not the vague kind. I'm talking about the phone in your pocket, the messages on it, the photos on it, the apps on it, and the location history that can tell police more about your life than your own wallet ever could. Most people think a gun case is only about the gun, but the truth is the gun is often just the door. Once that door opens, police may want your phone, your car, your bag, and anything else that might build a bigger case. That is why this Supreme Court decision matters across all 50 states. It set one nationwide rule on a question that affects everyday people during arrests. So let me break this down for you in plain English. This was a unanimous Supreme Court ruling. That means every justice agreed on the main result. And the result was simple. In general, police need a warrant before searching the digital contents of a cell phone taken from someone during an arrest. Not sometimes, not maybe. Generally, they need a warrant. Now, this is where it gets interesting. The case started with something small, a traffic stop, and that's exactly why you should care. Here's what just happened in the case that changed everything. A man named David Riley was pulled over in California for expired registration tags. That already tells you something important. The whole thing did not begin with a violent crime scene. It began with a normal road stop, the kind millions of drivers experience. During the stop, officers learned his license had been suspended. They impounded the car. Then they searched it under department policy. During that search, they found 2 handguns hidden under the hood. At that point, Riley was arrested for concealed and loaded firearms. Now stop right there and think about that. Imagine you are on the side of the road, lights behind you, adrenaline rising. You are thinking about the gun issue, the vehicle issue, maybe your permit, maybe your next words. But what you may not be thinking about is your phone. And that is exactly what makes this case such a wake-up call. After Riley was arrested, police searched him and found a smartphone in his pocket. An officer started looking through it. Later at the station, a detective looked deeper. According to the record, the detective was looking for gang evidence because, in his view, gang members often took pictures or videos with guns. The phone search turned up material the police used to connect Riley to a separate shooting. That evidence helped build much more serious charges. So ask yourself this: what started as a basic traffic stop turned into a gun arrest. Then it turned into a phone search. Then that phone search turned into evidence for totally different crimes. That is the part that shocked a lot of people. The phone became a treasure chest for investigators. And here's what most people get wrong. They assume if police lawfully arrest you, they can search every single thing on you from top to bottom, including every file on your phone. That used to be the government's argument. They basically said a phone should be treated like any other object found during arrest, like a wallet, cigarette pack, or folded paper. But wait, there's something even more important. A smartphone is not just another object. It holds your texts, photos, videos, banking details, health info, browsing habits, private messages, and often years of your life. That was the heart of the case. The court looked at that reality and said, in plain terms, that a phone is different. Way different. Searching digital data is not like checking a pocket for a weapon. It is more like opening a window into your whole personal world. And that is why this case matters so much for gun owners. Not because it erased gun laws, it did not. Not because it made every firearm stop illegal, it did not. It matters because it limits how far a gun-related arrest can automatically spread into your private digital life. If you're finding this helpful, imagine what you'll learn in my next video about the exact mistakes people make when police start asking questions during a gun stop. Subscribe so you don't miss it. Now let me explain what the Supreme Court actually said, because this is the part nobody talks about correctly. The justices did not say police can never touch your phone. They did not say your phone is magically protected from seizure. And they definitely did not say an arrest becomes invalid just because a phone is involved. What they said was more precise, and in some ways even more powerful. Police can usually seize the phone and secure it. In other words, they can take control of it so evidence is not destroyed while they ask a judge for permission. But when it comes to searching the digital contents, the court said the answer is simple. Get a warrant. That line matters. A warrant means police usually must go to a judge, explain why they believe the phone contains evidence, and get legal approval before digging through the data. That adds a layer of protection between you and a fishing expedition. Most people think privacy disappears the second handcuffs go on, but the truth is more complicated. The court said arrest reduces some privacy interests, yes, but not enough to let officers freely explore the massive amount of personal data on a modern phone. That was the turning point. Let me break this down with a hypothetical example to explain this. Say you are stopped late at night. Officers claim your tag light is out. During the stop, they discover a gun in the car. Maybe you are legal. Maybe they think you are not. Maybe they arrest you while they sort it out. Under this ruling, officers may seize your phone. But in general, they cannot just start scrolling through your messages, photos, and apps because you got arrested. That matters because your phone may contain things that have nothing to do with the stop: family photos, political messages, medical information, business records, location history, contacts, password resets, financial apps. That is not a small privacy issue. That is your life. Now, quick legal note: this is educational information, not legal advice. Always consult an attorney for your specific situation. Here's the part that surprised me most. The court understood that a phone is not just a physical object, it is a digital record of who you are. The justices basically recognized that allowing warrantless phone searches during every arrest would hand the government a tool far beyond what older search rules ever allowed. But here's the crazy part. This ruling helps you most when you understand what it does not do. It does not stop police from searching for weapons on your body. It does not stop lawful vehicle searches in every case. It does not stop officers from taking the phone for safekeeping. And it does not mean you should argue roadside and try to physically prevent a seizure. That would be a huge mistake. The smarter lesson is this: know the line. The line is between seizing the phone and searching its digital contents. A lot of people blur that line. The Supreme Court did not. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners and legal nerds who stay ahead of these rulings before they become problems in real life. Click subscribe right now. Now let's talk about the exceptions, because this is where people either get too confident or too scared. The court did not create an absolute rule with no emergency escape hatch. It said police generally need a warrant. That word generally matters. If there are urgent, real-world emergency conditions, police may still be able to act without waiting. Lawyers call that exigent circumstances. Fancy phrase, simple idea. An emergency can change the rules for the moment. So what kind of emergency are we talking about? Think about a suspect texting an accomplice about a bomb. Think about a child abduction where a phone may reveal the child's location right now. Think about officers chasing a fleeing suspect and needing immediate information to stop serious harm. In situations like that, courts may allow faster action without first getting a warrant. But here is what the Supreme Court pushed back on. The government argued that phone data could disappear through things like remote wiping or security locks. The court was not convinced that fear alone justified routine warrantless searches in every arrest. The justices pointed out that officers can often secure the phone while they seek a warrant. That is a huge detail. It means police do not get an automatic shortcut just because digital evidence might be lost someday. They still need a real reason for immediate action. Now, this is where it gets personal for gun owners. Imagine you are in a state with strict carry rules. You get stopped near a school zone, government building, or some other sensitive place. The officer sees a gun case, asks questions, and the stop escalates. You may be worried about permit status, storage rules, reciprocity, or whether the firearm was properly declared. All of that is serious. But if police also grab your phone, this ruling says that digital search is not supposed to be automatic. And here's the warning: do not make the mistake of thinking this case gives you a free pass to say or do whatever you want during a stop. It does not. Your behavior still matters, your words still matter, state laws still matter, the facts of the stop still matter. This case is a shield for digital privacy, not a license to ignore everything else. Another thing people miss is timing. A warrant may not come instantly. Police may hold the phone while they seek one. That can still affect your life, your work, and your stress level. So the real power of this ruling is not convenience. It is accountability. It forces a judge into the process before your digital life gets opened up. That is why I say this ruling reshaped privacy rights nationwide. It did not rewrite the Second Amendment. It did not cancel firearm restrictions, but it changed the rules of engagement when a gun case and a phone search collide. And in the modern world, those collisions happen more than people realize. Most people think the biggest threat during a gun stop is the firearm charge alone. But sometimes the larger risk is what investigators hope to find after that: old messages, photos, search history, contacts, trips, business deals, things that may have nothing to do with why you were first stopped. This ruling puts brakes on that process. This information still matters today, and too many people have never heard the rule. Subscribe now, because in the next video, I'm going to break down what you should and should not do the moment police start expanding a stop beyond the original reason. So here's the bottom line. A unanimous Supreme Court ruling made one thing clear. If police arrest you and seize your phone, they generally need a warrant before searching the digital contents. That matters for everyone, but especially for gun owners, because a simple traffic stop can spiral fast and your phone can become the next target. If this helped you understand your rights even a little better, subscribe and stay with this channel. Laws move fast, court rulings matter, and one missed update can cost you dearly. And remember, this video is for education only. It is not legal advice. If you are dealing with a real gun case or search issue, talk to a qualified attorney in your state right away.